Good evening. I'm County Supervisor Joe Simitian. Let's begin with a sound check. Can you all hear me loud and clear in the back of the room? Good. And let me say thank you for attending this. I guess this will be our second annual public meeting hosted by Santa Clara County to talk with you all about Lehigh Cement Plant and Quarry. Thought it would be useful before we get into questions and presentations to have just a little bit of background to help frame the conversation tonight. As some of you will know, I have now been back on the board. This is my second time on the Board of Supervisors for the last 4 years. Prior to my return to the board in 2013, the Santa Clara County Board of Supervisors took 2 actions that I think are probably worth mentioning tonight. In 2011, the Board of Supervisors made a determination on what are called vested rights. And at that time, the board determined where mining could occur without a use permit and where a use permit would be required. About 2,200 of the 35 acres property is vested for mining activities. And what that means is that proposals to mine outside that area require a use permit from the county. Proposals for mining or continued mining inside that vested area, not the case. So that was the decision in 2011. In 2012, the Board of Supervisors approved the amendment to the Quarry's reclamation plan, and that probably encompasses something like 1,200 of the 3,500 acres that we just referenced. So 2 actions by the Board of Supervisors that had been in place 2011, 2012, when I came back in 2013, and that have governed the operation of the quarry and the plant in the last 4 years. The reclamation plan outlines the plan and the timing for how the site will be restored at the end of the mining process. And the changes to the existing mining footprint that are within the vested area, any changes, I should say, to the existing mining footprint that are within the vested area would likely require an amendment to the reclamation plan. In other words, if there's a change, then you've got to have some sort of a process and a formal amendment. But within the vested area, we're pretty well squared away. Many of you in the room will know that both of those actions by the Board of Supervisors have been the subject of litigation, and I'm going to comment on that in just a minute. But I wanted you to know that since being sworn in 2013, my office and I have taken some steps to increase the oversight in ways that are perhaps incremental or modest, but that I think when taken together have the potential to produce and have produced a better result. After being back about a year and a quarter in, I guess it was April of 2014, I issued a memo to the Director of Planning and Development at the county, and I think we have copies out front. Let me just double check with my staff. If you're dying for a copy of that, it's out there. Essentially, I asked for 3 things back in the spring of 2014. The first was I asked that our county step up its visits to the quarry and cement plant. So what had been a kind of a couple of times a year visits or inspection, I asked that those be made monthly. And I did that for a couple of reasons. First was I thought it was important in terms of the county's oversight that we be on site, see firsthand what was happening, and be prepared to step up if it was called for. The other reason I asked for that was that it was clear that we were getting very different perceptions from folks in the community and folks at the plant about what was or wasn't happening. And it seemed to me that we had a simple solution to that problem, which was let's get our own people out there on a monthly basis, see what's going on firsthand, boots on the ground, and then we'll be able to say, no, we've been out there, we know what's happened. The second thing was I asked that there be biannual, meaning twice a year, coordination meetings with all of the various regulatory agencies that play a role on the site. One of the great challenges in managing the situation at the quarry and the cement plant is that there are at least a half a dozen, if not more, different governmental entities and agencies that have some responsibility for regulation and oversight. That, of course, means that it's a little hard sometimes to know who do you talk to about what kind of a problem. Also means that it's important that they all talk to one another and that they cooperate and collaborate and that the left hand knows what the right hand's doing and is, in fact, helping to make sure that it gets done. So since I made that ask, The folks who you're about to be introduced to and hear from have been meeting twice a year all together so that everyone's on the same page about what's happening on the ground and what kind of regulation and oversight are appropriate. The third thing I asked for was that after they had those couple of meetings each year to sort out their respective responsibilities, that there be one meeting like this every year so that we could both report out to the community but also take questions and hear concerns from the community. And we're going to get to that part in a little bit. So I am happy that all three of those things have happened, as I mentioned, over the last couple of years. I do think it has improved the county's role as well as the role of all the other agencies, that everybody's talking together, trying to work collaboratively and make sure that the job gets done. Now, as I mentioned earlier, this is the second public meeting of this type, and we anticipate that we will do this again. The reaction last year seemed to be a good one. We got a lot of emails from you saying that was worthwhile, please do it again. So we are doing it again, and we want to keep doing this as long as you find it valuable. A couple of other areas that I should say where my office, and I should be very clear, my office has no responsibility for oversight regulation of the plant. I'm an elected official. I'm one of 5. We make judgments as a board of supervisors. The actual day-to-day work gets done by the people who are here, some of whom are from the county, and I interact with on a regular basis, others of whom are from various state and federal entities, as you'll hear, or regional bodies, as you'll hear in a few minutes. But one of the things I asked my staff to do in cooperation with our county counsel's office and our county planning department was just to go back and review all of the conditions of approval for the cement plant to make sure that all the conditions were being followed. What we discovered was that there was a relatively small bond, I think it was $75,000 if I remember correctly, that hadn't been posted. It has now been posted because it's a requirement of the conditions of approval. It was missing, as I say, and we worked that through with the folks at Lehigh and with our own staff. One other thing I will say is that in response to the meeting we had last year, I did ask our county planning department if they could upgrade the website so that it was a little more user-friendly, because it seemed to me key to all of this was to make sure that everybody knew what was going on, what the facts on the ground were. As I said earlier, that has been done. Could it be better still? I'm sure it could. Is it appreciably better than it was before? I think it is, and hopefully you'll find much of the information you want on that site when the time comes. Last thing I guess I should mention is that following up a suggestion actually that came from last year's meeting as well, my office now has monthly conversations with the key staff people at Lehigh, usually with Carrie Saragusa, who's the head of their operation. More often than not, I have my staff member make that monthly call to both share concerns that we've heard from the community as well as to hear from folks at Lehigh about what they're doing to respond. My key staff person in that regard is Christina Loquist, who some of you have met and worked with before. If necessary, I get on the call myself, but frankly, that's a relatively infrequent occurrence. More often than not, it's a staff member, Christina Loquist, who is talking directly to the folks at Lehigh. And again, the notion is that if we're having those conversations on a monthly basis, it's less likely that things will just slide. Last thing I think I'll say before we move on is I'm guessing that a number of you are here as a result of increased noise levels that have come from the plant, which I know can be particularly troubling during the nighttime hours when most of us would like to be getting a good night's sleep. In the last 2 years, I would say our county environmental health staff has stepped up the monitoring and oversight as a result of the complaints being received. I believe that's had some impact. I also believe that there is still work to be done, lest you think that anybody thinks that problem's been fully resolved. I think we know it has not. We'll get into this a little bit more when we hear from environmental health, and I'm guessing we're going to have some audience questions on this as well. Before we get started in earnest, I want to recognize some of the elected officials who are here in the audience tonight. I want to thank you all for being here, but I want to thank Savita Vaidyanathan, who is the Vice Mayor of Cupertino. If you would stand. Rod Sinks, council member, recently reelected. Congratulations, council member Sinks. We also have Pete Siemens brought the whole rooting fam. That's good. We got Pete Siemens from the Mid-Peninsula Regional Open Space District. Thank you very much. And I think Alex Wong is here from Senator Jerry Hill's office. There you are. Thanks for being here, and thanks, Senator Hill, for sending you out on a school night, okay? We appreciate that. The other thing I think I should do at this point before we get to the panel is to thank the City of Cupertino. Both last year and this year, they've been just great. I wish I could tell you that I treated for the cookies, but I did not. They did, and they have made the room available and are making the stream and the recording available as well. So we thank them for all of that to make sure that everybody gets a chance to participate. And what I'm going to do in a minute is I'm going to ask the panel to introduce themselves briefly. I'm also going to ask them to say briefly what they do in connection with Lehigh, either the cement plant or the quarry or both. And then after those brief introductions, I'm going to ask them some questions that fall into the category of frequently asked questions, at least in the experience of my office. And then after we've got that sort of a baseline out there, and I'm guessing that'll probably take about half an hour, we will move into the portion of the evening where we take your questions. If you have a question, please write it down. The cards are right there at your place. If you need more, we've got someone right here, so just raise your hand either to hand off a card that's already been completed or to get another card, and my staff will make sure that they either pick up or deliver a card as you would like. And as I mentioned earlier, I just want to let you know that the meeting is being taped, so I don't want to make any of our folks camera shy, but you just want to be mindful of that as we go forward tonight. So let me begin by asking the panel to introduce themselves and explain their role and the role that their agency plays in regulating what takes place at Lehigh. And why don't we start closest to me and then work our way all the way down to Miss Bianca at the end, who looks like she's almost off the stage down there. So please begin.
Thank you. Good evening, everyone. My name is Joel Jones. I'm the Assistant Director for Enforcement at EPA in San Francisco. Thank you, Supervisor Simitian, for setting up this public meeting as well as last year's. And the first thing I want to mention in terms of our role, and it's much different, as you'll notice, I think the only federal official here, is as an oversight agency, EPA is responsible for regulating 7 or 8 national statutes, environmental statutes, and within that 14 or so programs. And within EPA, I manage about half of those here in the region. We cover California, Arizona, Nevada, Hawaii, Pacific Islands, and most of the rules, as you'd expect, are designed for national implementation. Locally, a lot of states and local agencies have more stringent or more strict rules than EPA does. But if nothing else, our role is to make sure that at a minimum, the federal standards are being met. And we'll probably get into this more in detail later about our view of the case here. But we do have one ongoing enforcement action that some of you are probably aware of. It's been going on for a while. And I really can't speak to the specifics of that because it's enforcement confidential. But I do know that we're hopeful to resolve that case in the very near future. The one caveat I would insert is that it's not a matter of imminent substantial endangerment. It's a programmatic kind of case. And I think once it's resolved, a lot of the issues, the local issues may or may not be affected by that because the case we've taken doesn't have a lot of the particular issues that have been raised locally. So I'll, with that, pass along to the next member here.
Okay, good evening. I'm Wayne Kino. I'm the Director of Compliance and Enforcement for the Bay Area Air Quality Management District. We have jurisdiction of air quality in the region. We have 9-county jurisdiction. We have delegated authority from both the EPA, the state, to enforce their rules, and we also write our own rules. And we've been regulating Lehigh for quite a while, and we have several rules that apply to Lehigh. We are continuing to examine Lehigh, looking at improvements we could make, continuous improvement types of things, and we'll be happy to talk about that later on tonight.
Thank you very much.
Hi, I'm Julie Macedo. I'm Senior Staff Counsel with the State Water Resources Control Board, and I represent the San Francisco Regional Water Quality Control Board for Lehigh Matters. The Water Board handles both enforcement and permitting issues. We gave Lehigh a new permit and a cease and desist order in the spring of 2014, and the first enforcement action under that permit structure is out for public comment. We made sure to make sure it was available for public comment at the time of this meeting, so you have until mid-December to comment on it. But we've also made our permit structure consistent with the Sierra Club lawsuit that you may all be aware of, that involves a number of activities at the facility that we think are moving in the right direction, especially the interim and soon-to-be final selenium treatment, which is really improving things and consistent with the way we regulate Lehigh.
Thank you very much.
And I'm Jack Gregg with the Regional Water Quality Control Board, San Francisco Bay Region, and it's a state agency that deals with water quality in the Bay Area for the counties that drain to San Francisco Bay. We have a large contingent of our staff working on Lehigh, working on the groundwater aspects of it, on discharge from the quarry. They have to have an MPDS, National Pollution Elimination Permit for that. So that's what Julie was talking about. They've been regulated under that. We have our planning staff working on a total maximum daily load for the selenium leaving the site, so that we have a number that we know how much selenium is leaving the site when we're all said and done, and how much they need to reduce the selenium to protect our waters. And we have enforcement staff involved with Lehigh. I have been helping our Assistant Executive Officer, Diane White, with coordinating all these staff, and she couldn't make it tonight, so I'm here in her place.
Thank you very much.
I'm Brett Calhoun with the Santa Clara Valley Water District. I'm a geologist by training, and I carry the title Associate Water Resources Specialist. As you may know, the Water District is not a regulatory agency, but I have been involved with various investigations looking into sediment concerns for the last 17 years with the cement quarry through its various owners. And I have worked very closely with the Regional Water Quality Control Board staff and the county staff and Fish and Game Department staff on those issues. Our charter is to ensure that our water quality in our creeks is meeting the NPDES requirements. So we keep an eye out on our sections of the creeks, as well as those sections of the creeks held by other public agencies.
And before we go to our next speaker, I should just clarify, some of you will know, but not all of you will have any reason to know, that the Santa Clara Valley Water District is a separate legal entity entirely apart from the County of Santa Clara. So they are their own governmental entity. They have their own elected board that governs them. Different organizations, though, altogether from the County of Santa Clara. There's occasionally some confusion about that. And also with us is?
Hi, my name's Dave Johnston. I work for the State Department of Fish and Wildlife, and I work for the Habitat Conservation and Planning Branch, which is the entity that would deal mostly with quarries. And we deal with quarries in a number of ways, but the two primary ways are that we're available for consultation either by the quarry itself or by the local permitting agency, which in this case would be the county. And the second way is that we would need to issue an authorization for work that affects the bed, bank, or channel of any water course drainage within the quarry area. And so far, we haven't issued a permit because it's not ripe yet. There aren't a final set of plans, CEQA hasn't been done, things like that. But we have been working on and off with the county and Lehigh probably for about the past 8 or 9 years.
Thank you.
Good evening. I'm Rob Eastwood. I'm the planning manager for the county planning office. In our role, Supervisor Simitian did a nice introduction. Probably 3 hats or oversight areas. First, we implement SMARA, which is the State Mining and Reclamation Act, and so we're the lead agency that it requires for all of our quarries. They're required to reclaim the site in the end and leave a site that's stable and doesn't have a legacy issue. So our primary responsibility on Lehigh, I'd say, is to ensure that the reclamation plan that was approved for the site continues to be implemented. And we do hold a large financial security to ensure that that happens. There might be some questions about that later. Second off, we have general land use oversight of quarries and cement plants and operations. As of that matter, as Supervisor Simitian mentioned, the current quarry operations was determined to be vested. It does not need a use permit. The cement plant does operate under a use permit. It's an old use permit. But as Supervisor Simitian mentioned, there's a series of conditions of approval which the county must enforce. Last but not least, to the extent the quarry applies for building permits from our office, the building department in our office, and our building folks plan, check, and inspect those building permits.
Thank you very much.
Good evening. My name is Michael Ballier. I'm the Division Director for the Department of Environmental Health, and our primary role at this point has been to respond to the noise complaints that we've received over the last 2 years. And we do have inspectors and investigators that receive those complaints and then go out and actually do noise monitoring with our monitoring equipment.
And before we go to our next speaker, we have folks from environmental health and planning, as you heard. Gentlemen, are your bosses in the office in the building by any chance?
Yes, they are.
I'll go ahead and recognize two people.
Yeah.
So the Director of Planning is standing in the back row. His name is Kirk Gerard, and he's who I report to.
And Jim Blamey, our Director of Environmental Health, is also here.
I just want everybody in the room to know the adult supervision is here as well. Okay? Thank you.
One last thing, and I'm
Please.
sorry to enter. As those who attended last year and do a lot of interface with office might have recognized Marina Rush was a planner with our office who worked a lot on Lehigh. She retired earlier this year. I'm a bit hesitant on this because he's still in training, but will soon be in the role. But I did want to recognize we do have a new planner who's starting to oversee our Quarry program. His name is Chris Holm, and he's in the front yard. I'm a bit hesitant. Once his name's out there, he'll get a lot of calls, but it was going to happen anyways. So just want to recognize his presence and as a resource for people for planning.
Thank you both.
Good evening. I'm Jennifer Ka'aha, and I'm also from the County Department of Environmental Health, so I'm a Hazardous Materials Program Manager. And we get involved with Lehigh because we are the agency responsible for implementing 6 state environmental programs related to hazardous materials and hazardous waste. It's collectively referred to as the Unified Program. We make sure that they're in compliance with those programs. We also have a couple of local ordinances. One is a hazardous materials storage ordinance that applies out there. We're focused primarily on preventing the release of industrial chemicals to the environment and minimizing the impacts of those releases when they occur, usually through prevention and preparedness type methods. So we inspect Lehigh. They are subject to 6 of the regulatory programs that we implement. Our underground storage tank program. We have an above ground petroleum storage act program. We deal with hazardous waste. California Accidental Release Prevention Program, which deals with sort of high hazard chemicals. We have a hazardous material business plan program that deals with the disclosure of hazardous materials, both for emergency response purposes and also for public right to know. And then we also have our local hazmat storage ordinance, which applies at the facility. So we're out there doing routine inspections periodically, as well as doing construction plan checks in a couple of our programs, our hazmat storage program and our underground storage tank program.
And finally?
Good evening. My name is Elizabeth Pianka. I'm an attorney in the County Counsel's office, and I advise the county in conjunction with our county council on legal matters related to Lehigh.
Thank you all. I just wanted you to see who some of the players were. More than half a dozen different agencies who are here with us tonight, 10 people who are here, another handful who are in the audience. I want to confirm, I didn't grab my copy of the agenda on the way in, but I believe if you flip the agenda over, you will find contact information for all of these people. So want to make sure that you have access to folks who will need to hear from you during the course of the year about any issues you have with the plant or the quarry. I'm going to move right into some questions. As I said, these are frequently asked questions, and my hope is that that will establish sort of a baseline of information about things that have been current or important, or both, and then, of course, we'll take additional questions if they are not issues that we've already addressed. So let me start with the Bay Area Air Quality Management District. The new stack, as it is sometimes referred to, has been operational for over a year now. Could you describe for us the impact that that's had on emissions? And I guess part of the way I would ask the question is it what we were expecting and hoping?
Okay, good. Thank you. Yes, the stack is in place. The way the stack was put in place was that through regulatory effort on our part, we wrote a rule, a law, that basically didn't specify that Lehigh had to put in a stack, but established parameters in which, in order to comply, they had to put in a single stack to route all the 32-plus stacks that they had into one. What that did was it concentrated all the emissions into one single stack, where we have continuous emission monitors that monitor what comes out. So what the stack did for us and for you is to put all the emissions into one location where Lehigh could install monitors and monitor what's coming out of their process. So in that, it sort of gave us certainty of what was coming out. What the rule also did, and the stack does, is that it established limits on various components that come out of the stack. So we're monitoring. There are also standards for each of the compounds that come out of the stack, and that is being monitored. And so we have some assurance of compliance, and we can determine when there is some non-compliance issues also with Lehigh. What the rule resulted in was that they are complying with most parts of the rule. There was a couple areas. Whenever you write a new rule, there are areas where you don't anticipate certain things. And one of the areas that we didn't anticipate is that we also, I need to explain, we also monitor opacity, particulate matter in the stack too. There's an opacity monitor there. They are in compliance with that. What the public has been seeing, though, is a plume coming out of the stack occasionally, and we get complaints on that. And what's happening there is that one of the control devices is an ammonia injection, which controls NOx. It's a precursor to smog in the area. And what is happening is that the raw material coming into the process has some nitrogen compounds in it naturally, and that varies. And the ammonia injection for the control device to control NOx is injected to meet our standards. What's happening is that there's what we call ammonia slip going through. So there's some ammonia coming out of the stack. It doesn't present itself until it actually exits the stack, and it creates what we call a secondary plume. It's a detached plume. It forms outside the stack, so the opacity monitor isn't monitoring it in the stack. It's forming outside the stack. So we're doing some research on that. We're trying to figure out how to control that, how to better get a handle on that, and to eliminate that. So that is one of the challenges, and I talked earlier about how we try to continuously improve. Whenever you add controls or Lehigh adds controls, there's always some consequences, sometimes unintentional, and we are continuing to work with that. We are writing other rules, and I can talk about that later.
Why don't we follow up right now, and let me just ask for a slightly less technical explanation on one piece of this. So what I heard you say, and I want to make sure I heard it correctly and that we're all on the same page, was that based on the testing, the emissions are within the required guidelines, essentially, for the most part, yes?
That is correct, yes.
Okay. Then the other question I want to ask, having listened to that very technical explanation, is it better than it was last year? So a year later, can you say we feel better about the air quality as a result of the emissions after rather than before? I'm looking for a before and after comparison if one is possible.
I think it's a complicated answer. I think the answer is yes.
Okay.
What the stack did was it gave us assurance of what's coming out. Before, we really didn't know because of the 30-plus stacks. So we couldn't monitor every single stack. We could source test, bring a van out and source test each stack individually, but we couldn't do all 32. At this point, we can do a single stack.
Do I remember correctly that the stack is higher?
Correct.
And in theory, that if there's a higher stack, that means that if there's going to be something to be dispersed, it's at least dispersed higher and farther away from the public?
That is absolutely correct. There's more dispersion, there's more loft, and it doesn't impact at ground level.
All right. And you mentioned some additional regulations that either have been adopted or are potential for adoption in the foreseeable future. Could you tell us in the most layman's term possible what they are,
yes,
but also why they are a good thing and how they will help us in terms of health, safety, and welfare of the folks in our area?
Okay. We have a rulemaking effort going on right now. In fact, there's a workshop in Martinez tonight. We were down here in San Jose yesterday, And what it is, it's a rule that applies to every facility in the Bay Area. So we have some 6,000 permitted facilities, and it applies to every single one. What it is it is a risk reduction rule. So what it does is it takes what emissions, we figure out what emissions are coming from each facility, and what it does is sets a standard on the calculated risk that facility poses on the community. It's a very complicated formula, but it basically looks at what's coming out of the facility. It looks at the receptors, it looks at topography, it looks at height of stacks, and it calculates what the risk is. And we have set our proposed risk standard, which is basically cancer rates, additional cancer rates, at 10 in a million, which is the most stringent in the nation at this point. So we are going for that. We're in our rule development, and we hope to pass that rule sometime second quarter next year. It would apply to this facility, and this facility would then have to look at their risk. There's new calculations and new factors that are more health protective for the country, or for the state, which takes into account at-risk individuals, so people, elderly, children, and those standards have been modified and dropped to a much lower level on the state level. So the overall effect of all these standards dropping is that a facility with the same emissions, their calculated risk would be 2 to 6 times higher than it is now. So that, with the same emissions, so based on the new emission factors. So that is a very health protective. We're going to be lowering that and being pretty health effective for everybody. So
Did I understand you to say that the level that the standard that you are pursuing would be the lowest in the nation?
Correct. It would be it would be at par with the lowest at the nation, and I think it's one of the lowest in California. Yes.
And if people who are here in the room or who are watching want to weigh in on that rulemaking process, is there a readily available way for them to do that?
Yes, it's on our website. The workshops are, like I said, are currently going on. There's 6 workshops. We have tonight's Martinez, tomorrow's Fremont. You can look on our website, you can provide comments, all the draft rules, the draft staff report, all that information is on our website.
Great, thank you very much. Let me go to US EPA right now and sort of circle back on a comment you made earlier about different levels of government. Frankly, some of them overlap, some of them don't. I think it can be confusing even to people who are relatively engaged and knowledgeable. Could you tell us a little bit more about US EPA, the United States Environmental Protection Agency's role in local environmental program enforcement and what your agency's priorities are in particular?
Sure, absolutely. So just for, most of you probably know this, EPA was established in the 1970s, early 1970s by Richard Nixon. And the main statutes that relate to this facility, the Clean Air Act, the Clean Water Act. We've had some issues with our emergency planning and community right to know, which is kind of known as the Toxics Release Inventory, TRI program. So we've taken actions against Lehigh under both the Clean Water Act and under EPCRA, the TRI program, from last year. And then this year we have an ongoing, as I mentioned earlier, the Clean Air Act concern. Generally speaking, EPA nationally has about 15,000 employees. Most of those are in Washington, D.C., writing rules, setting standards across the programs, air, water, waste, et cetera. In the region here in San Francisco, we have approximately 700 or so staff and managers. And within each of the programs, we may have, say, 50 or 60 people. So in enforcement, we have about 80 people total doing environmental enforcement here in the region. And so among that, we have all of the programs, the Clean Air Act, Clean Water Act, et cetera. And so the number of inspectors, say, within each program is fairly small compared to what the state of California has. I don't know the specifics, but I know that in one of the air districts specifically had 12 inspectors out in the field just last week, something we aren't capable of doing, but that's by design. In the 70s and 80s, most of the statutes, we delegated responsibility for enforcing those to the states, and in California it's unique. They have air districts for the air program, the water boards for the water program, et cetera. We still retain enforcement responsibility for all states if, in fact, a state fails to or doesn't live up to their agreement with us, the memorandum we have with them to enforce those rules. Fortunately, in California, we have some of the strongest air quality and water quality programs in the nation, as you've heard a little bit about tonight, and I'm sure you know. And so the rules set by the state in some cases can be added to in the case of Clean Air Act, and we can implement those as well. And in other cases, the rules are just taken and implemented by the local air district, and they're not federally enforceable because I think nationally, keep in mind, we're setting standards across the entire U.S. and for a level playing field, for geographic reasons, regional differences, there are different reasons for the rules that some individual communities want to enforce and or implement that are unique to those communities. And I think in California, they're fairly strict and stringent across the board. And so the cases we've taken usually are things that either have not been delegated to the state or infrequent circumstances when a state fails to act. That doesn't happen as much in California as it does in perhaps some of our other states. But I think for context, the one program that is just federal, and that's the TRI program, the Toxics Release Inventory, it's basically a reporting program. They're simply supposed to report various constituents and chemicals that are in the processes at the facility. It isn't a matter of levels, whether or not it's high or low. It's just a requirement that they report those levels to EPA. In the case of Lehigh, there were a couple of minor violations a couple of years ago that we addressed through the enforcement action. And that's one program that's not delegated to the state. But it's as it's called, it's public right to know. The reason for it is for the public to be aware of the kinds of contaminants and chemicals that a facility is processing. It doesn't necessarily set permits for those things. That's done by the air district in this case and or the water program, et cetera. So I think for context-wise, we have an oversight authority that can be implemented locally, but it's usually only done when the state fails to act and or the state has not implemented our program properly. That's rarely the case here and definitely not the case in Cupertino.
My shorthand for that is you're our belt and suspenders.
Yes, that's a good way of looking at it.
I'm going to spend the entire evening trying to oversimplify everything everybody says at this table. So I just want to make sure that my takeaway is correct so that we're all on the same page about who does what. Let me go to California Fish and Wildlife. It's my understanding some progress has been made regarding the creek restoration efforts on Permanente Creek. What can be shared with the public about sort of the status of that?
So Lehigh and the Sierra Club went back and revised the consent decree because of some concerns that had turned up. The revised consent decree was reviewed by the department before it was finalized. We are in full agreement with the revised consent decree. Based on that revised consent decree, Lehigh produced a new draft set of plans which we have also reviewed. And essentially, the bottom line is that we went from a project that we would not be able to approve to one that we would be able to approve. It's a very large, complex project, and when they turn in a set of plans, there's still going to be a lot of field modifications. So we're going to be working very closely, both with the county, other agencies, and Lehigh during the process of that. But as I say, this is a project that we can issue a stream bed alteration agreement for.
Thanks. As I hear from the folks I represent, I think there continues to be concern as well about what I'll call general impacts on wildlife, particularly endangered species, particularly with respect to pollution, and I'm thinking of the selenium levels that have been identified in the water. What should we know about the work you and your federal counterparts are doing in that area, if anything?
Well, the department's mission, to address a broader question first, the department's mission relates to all of the state's fish, wildlife, and under Fish and Game Code, you're either wildlife or you're fish, so invertebrates are fish as well. But we have jurisdiction over the fish, wildlife, and the habitats that sustain them. So during our review, we look at all of those. The Federal Fish and Wildlife Service is going to be involved too, and they have jurisdiction specifically to California red-legged frog, which is a federally listed species. There do not appear to be any state-listed species, so we're going to address concerns through our stream bed alteration agreement process. The selenium issue is more complicated, and I'm going to give you a rambling answer, and at the end of it, I'm going to say I don't know. But This is California, so sometimes the journey is more important than the destination. So the EPA has established standards for toxicity of selenium in natural systems. The recommended level is 2 micrograms per liter. The two that we care about other than that one are called chronic and acute. Chronic is 5 micrograms per liter. Acute is 20 micrograms per liter. The indications are that prior to the quarry, the levels of selenium that naturally occurred in the system were very, very low, very difficult to detect. And we know that because we have samples that were taken above where the quarry is now. So selenium levels in the water column can be very high during high flows, up to 30 to 40 micrograms per liter. However, research has shown that the level of selenium that's dissolved in the water column really doesn't have that much to do with the impact that it's having on fish and wildlife, vertebrates in particular. So a better way to do that, well, the best way is to test the organisms directly, which in this case is kind of hard because they're a federally listed species. But a better way than to measure the selenium in the water is to measure it in the sediment. There have been 2 sediment samples taken and tested. The levels are between acute and chronic. So the most reasonable explanation, or the most reasonable conclusion from that, is that there's high enough levels of selenium that can get into red-legged frogs to create a problem. However, the literature is all over the place on the effect that selenium has on different organisms. I only know of one study that was done on an amphibian, and that was unfortunately done on clod frogs. And clod frogs are a species that are resistant to any kind of control at all other than large rocks dropped from high. They're just a terrible, terrible species to use for this kind of thing. So this is why I say I don't know. Selenium harms vertebrates through the food chain. So we know that there are elevated levels of selenium that we don't like in Pond 14, which is California red-legged frog breeding pond. There have been no reports of deformations from the few sightings that people have, so there's no overt stuff. But the real issue is, how's it affecting the overall population? And the only way to really measure that is to do a very long-term study and count all the eggs, and then see if you can count how many of them turn into frogs that lay other eggs, because that's really the key issue. So how this is going to play out, I don't know. This is going to be up to the Fish and Wildlife Service, the federal group, because they're going to have to issue a biological opinion for the work. And I wouldn't be surprised if they asked for more testing and essentially said, okay, we're going to start with testing the frogs themselves to see what the levels are like. But even when that's done, there's zero literature on how it affects populations of ray-kneed frogs at all, let alone California red-legged frogs.
So, to again try and sort of boil some of that down, some degree of uncertainty, but selenium levels that remain high enough to be a source of concern. Is that a fair statement? And you are coordinating with the federal Fish and Wildlife Service, yes?
Yeah, I actually spoke to Joseph Terry, the Fish and Wildlife representative, this morning, and let's just say it was a head scratcher.
Okay.
It's not something they deal with.
And just so folks here know, we did extend an invitation to the federal Fish and Wildlife. They were unable to join us tonight. We appreciate the fact that the state was able to send Fish and Wildlife to be with us tonight, so thank you for that. All right, let me then go to the Water Board and ask what the status of the Water Board's enforcement efforts are at Lehigh, and is there anything new to report since the last time we got together?
There is. I believe I was here last year, and I believe the consent decree was close to final, if not final, and the consent decree is a joint basically settlement agreement between the Regional Water Quality Control Board, so the state agency, and EPA, so the federal agency, and Lehigh. And so the purpose of that was to take the Regional Water Quality Control Board permit, so as you listen to EPA and his statements that basically EPA delegates the authority to California, we have done that, and we regulate and permit the Lehigh facility. So we, in, I believe, spring of 2014, issued a new individual site permit to Lehigh, along with the cease and desist order. The consent decree with the Water Board, EPA, and Lehigh formalize those terms in the Sierra Club lawsuit. And what that means is everything is enforceable in a federal court of law. So to the extent that the consent decree has specific terms, if Lehigh violates it, EPA or the Water Board can go directly into court, and it doesn't necessarily have to start a long process of informal enforcement efforts. The consent decree is a document that gives a judge continuing jurisdiction to go in and say, this needs to stop, and on certain occasions there's stipulated penalties for violations. In terms of Water Board specific enforcement, as I said, that permit and CDO were finalized about 2 years ago, and they take into account the interim and final selenium treatment plans that were sort of won by Sierra Club in their lawsuit. And so we have a current enforcement action pending. It's out for public comment that deals with MMPs, what are known as mandatory minimum penalties under the Water Code, which are essentially effluent violations. So when a constituent tests higher than the Regional Water Quality Control Board has permitted Lehigh to discharge, we automatically get a minimum penalty of $3,000. In addition, it has discretionary violations under the Water Code for some stormwater violations. And so that settlement is out for public comment, and to the extent that you want to comment on it, you can. There's an email address that takes into account any of your comments, and then if there are no public comments, the settlement will be finalized and a check will be issued.
And you mentioned that the fine was forthcoming if there were certain constituents that tested higher. Did I hear that correctly?
Right, a mandatory
The
minimum.
reason I'm asking is I have constituents, and I don't think that's what you're talking about.
Sorry.
So for folks who don't know what constituent means in the context of this conversation.
Chemical constituents. So, for example, we set certain limits for pH and turbidity and such as those things.
I'm going to call those potentially bad stuff. Is that a fair summary?
Yeah, the way you're summarizing everybody, that's fine.
Okay, good. All right. Anything else on selenium in particular that you want to share with us?
I mean, I think we want to talk about how the interim treatment system has been working. And so I think you asked the gentleman for the Air Quality Management District if things are better. And the interim treatment system is installed, it's operational, and the final treatment system is due to be operational in about a year. But those MMPs I mentioned, the mandatory minimum penalty, which test a number of constituents, so not just selenium by any stretch of the imagination, but our settlement agreement goes through December 31st of 2015, and in that it has approximately 61 MMPs, and we did a count to bring everything current prior to this meeting, and in 2016 there are 8 MMPs that we're aware of. So the decrease from 2015 to 2016 is pretty significant.
Thank you. Good to hear. Let me go to the Water District now, if I may, and more than a couple times now, selenium has been part of the conversation. It's been my experience that there's been some concern in the community about the possibility of contaminants more broadly, but certainly including selenium, getting into the groundwater and then potentially into the drinking water. What level of concern, if any, should we have about that?
That's going to help. So with regard to selenium in the drinking water, Permanente Creek is not a significant recharge facility for us. There would be a very small section of creek that would allow water into the recharge zone for constituents downstream of there to get water from wells. So groundwater recharge takes a long time, so the selenium really isn't a concern, and water quality is tested for all drinking water. So people downstream of or getting what limited water goes into the recharge For that watershed area, it would be tested by, the city of Mountain View, the city of Los Altos, and others to ensure that it meets the EPA drinking water quality requirements. That said, we have been up to the plant to see the pilot plant for the selenium. We do monitor our, we do keep track of all these things and are interested to know what, the concentrations of selenium are. And I would agree with the Fish and Wildlife Department that selenium and its bioaccumulation process is very confounding. And in its natural state, it's not a huge concern for water, just like we're dealing with other pollutants like mercury.
Okay. And one quick process question. I mentioned earlier that sometimes folks are understandably confused about the water district and the county being two separate agencies. I think equally challenging, if not more, is the fact that the water district has one set of responsibilities and the Regional Water Quality Control Board has another set of responsibilities. Is there an easy way for people to understand who to go to with what set of problems or concerns?
So I can take that. Since I've been on this project for about 17 years, the Water Board is our partner. So Santa Clara Valley Water District, I work under both projects of what was the special tax pass for Clean Safe Creeks and then now Safe Clean Water. So our role is stewardship. We do have a water utility business and we have a flood control business, but I'm on the stewardship side. So even since 1998, when we would have a concern, we go straight to the Regional Water Quality Control Board with that concern, and we have unlimited access, as well as with the Fish and Wildlife Department. So in the late 90s, I was in contact frequently with concerns about sediment discharges at what was then Hansen. And that continues to this day. That's why we're involved with the committees and the regulators, is that we maintain that line of communication. So if I hear from the public on any issue, not only will we probably respond to the field, but we will respond and direct complaints to the county, the water board, and others, and try to pull it all together.
Does that mean that it's not only okay, but productive, whichever of your two entities they go to?
Very productive. So from a regulatory, ongoing regulatory permit requirement, we would go to the Regional Water Quality Control Board. For a direct violation or a fish kill or something like that, we immediately go to the wardens.
Okay. Let me go to county planning. The county, as was mentioned earlier, is the I guess I'll call it the lead agency when it comes to implementing the Surface Mining and Reclamation Act, known as SMARA. The question I have is, what progress have we made over the past year in implementing the 2012 reclamation plan? So we have a 2012 reclamation plan. We have this lead agency responsibility. Progress, if any, over the last year to report?
Sure, and I'll try and be pithy to save you the summary later, Supervisor Simitian, but feel free to weigh in if I don't. So as Supervisor Simitian mentioned, the Board of Supervisors in 2012 adopted a reclamation plan. Again, that requires that when mining stops at the Lehigh Quarry site, it be reclaimed. As many mentioned, hundreds of years ago, there was mining throughout California, many places where legacy issues were left with chemical concentrations or unstable sites. And the principal objective of SMARA is to make sure that mining operations leave a site that is stable, does not have legacy issues. And I'll speak to one that's of concern of everyone, and that is selenium. So in the 2012 reclamation plan, and there were a lot of studies that went into it, it does require that the quarry must be reclaimed in a way that gets selenium levels down below Regional Water Quality Control Board standards. So the quarry will not be reclaimed until the main pit is backfilled, the waste sites such as the east material storage area and west material storage area reclaimed, that the water discharge from that site after the reclamation happens meets those regional water standards. So that's really a requirement SMARA that hinges together these water quality standards. As mentioned, the reclamation plan was approved in 2012. We require an annual report to our planning commission that puts eyes on the status of the reclamation plan. We go through all the conditions of approval. As Supervisor Simitian mentioned, we have staff that goes out to the site on a monthly basis and other specialists to go out to the site to monitor what's going on. We go to our planning commission once a year. We'll be going this December if folks would like to show up. We do an annual report. So far, in general, the quarry's been in compliance with the reclamation conditions of approval. The one issue that is ongoing, and it crosses over with many other agencies, is selenium. So again, the long-term projection for the quarry is that selenium levels will decrease. The struggle has been that while the quarry is still, in some senses, mining and is in active reclamation, it means it hasn't been reclaimed yet, but is in the process of reclaiming, the selenium levels have not come down below regional board standards. There's a requirement in the reclamation plan to evaluate any feasible measures to get those standards down. But to date, staff hasn't determined and the Planning Commission hasn't determined that in some areas of the site, and this is really the east material storage area, that there's a feasible way yet to do so. Most recently, Lehigh has started to put in some measures to control water quality and reduce selenium levels. That includes doing some modifications to the Pond 30 in the east material storage area and installing a French drain. We're hoping those are going to do good work on reducing those levels. Lehigh is also has capped the east material storage area that's intended to prevent stormwater and rainwater from interfacing with the waste material and causing selenium runoff. To date, we're still monitoring the water quality that comes off of it, but we're hopeful this year and the coming years those actions, and they're required to, will reduce the selenium levels down below the standards.
And my Joe Simitian District 5 version of the reclamation plan is it's the means by which we make sure that when folks close up shop and walk away, they don't leave any of their problems behind for us.
That is absolutely correct. And just to reiterate, the county does hold a financial assurance. So it's not just a promise. We've never had to do so yet. But if, for instance, a quarry operator was to leave the site, the county holds a financial instrument which financially supports reclamation of the site.
So I know folks in the community are also anxious about the fact that the limestone in the existing quarry will run out at some point, and quite possibly sometime soon, and that the operators may want to continue operating. Could you share with everybody here the county's process in the event that the folks at Lehigh request what I'll call a new pit, for lack of a more technical term?
Sure. And we get that question quite often. I know it's a concern of the community. And for historical status, Lehigh, I think 7 or 8 years ago, had proposed a new pit on lands they own. To date, our office has not received any proposal, any indication for a new pit. As Supervisor Simitian mentioned, it's known that the material on site at some point will run out. If the quarry operator does propose a new pit, we would first have to examine, is it subject to our land use oversight? Will it require a use permit? As Supervisor Simitian mentioned, the county board determined some areas of the site are vested, which mean quarry operations had happened so long ago that active quarrying doesn't require a use permit. If a new pit was proposed in those portions of the site, it would not be subject to a use permit. If it's proposed in a portion of the lands that Lehigh owns that is not vested, to which there's no past evidence of mining, it'd be subject to a use permit. And so with a use permit, the county has the ability, has to make findings that it meets health, safety, and welfare requirements, that there's neighborhood compatibility. The county has the ability to approve or deny a use permit application. And above and beyond that, the quarry would be required to meet SMARA, which is, again, if a use permit is approved, permission is granted to mine, that it be reclaimed afterwards.
I just want to underscore the comment that was just made. The reason this issue of vested or not vested, which can sound a little abstract, is important is because if there's an application on property that is not vested, it means the issue of a use permit is front and center. Am I right so far?
That is correct.
And the reason the issue of a use permit is an important one is because that allows an up or down decision, and in addition to an up or down decision, it also allows for conditions of approval that otherwise might not be imposable. Is that also correct?
That is correct.
Okay. And let me go to County Council then, because, and County counsel is our lawyer at the county, so that's what we're talking about. And Elizabeth Bianca is here from the county counsel's office. Her office and mine work together quite a bit. There have been a number of lawsuits filed over the past few years, some of which have made their way through the system, some of which are still making their way through the system. Let me ask Ms. Bianca if you could give us a brief update on what they are and where they are.
Certainly. So as Supervisor Simitian mentioned earlier, there were two pieces of litigation. The first related to the Board of Supervisors 2011 vested rights determination, which as mentioned vests property such that you are not required to obtain a use permit. And the litigation last year, I believe, I had mentioned that the item had been fully briefed before the 6th District Court of Appeals, and we were waiting for oral arguments. The trial court, so the Superior Court of Santa Clara County, had ruled in the county's favor at the trial court level and had found that the county's vested rights determination was upheld by substantial evidence in the law. That decision had been subsequently appealed to the 6th District Court of Appeal. And earlier this year, the 6th District issued an opinion that upheld the county's determination and upheld the vested rights determination in 2011. That decision is now final. There was not a further petition for review filed with the California Supreme Court, which would be the next step in the litigation by the petitioners in that case. The second case that Supervisor Simitian mentioned earlier relates to the county's 2012 approval of the Reclamation Plan Amendment under the state SMARA law, as well as the county certification of the environmental impact report. Again, last year I believe I reported that that case had been fully briefed before the 6th District Court of Appeals and was waiting a hearing. The county did prevail at the trial court level in Superior Court for the county. The decision was appealed. There was arguments earlier this year, and in August, the 6th District again upheld the county's approval of the reclamation plan and certification of the EIR. That litigation, there was a petition for review filed by petitioners in that case with the California Supreme Court, and the Supreme Court has, I believe, until early January to decide whether or not to grant a petition for review, which would then start another process of briefing and hearings before the California Supreme Court. In the interim, though, the reclamation plan and the EIR is valid, and if the California Supreme Court denies the petition of review, that will be the end of that litigation.
Thank you. Let me insert myself again here at this point in the conversation to say I have as an elected official and as a county supervisor, and just by virtue of sort of my view of the world, I have a slightly different take on litigation than the county counsel's office. And the county counsel's office understandably doesn't like to hear that the county has been sued, and the county counsel's office also has the duty to defend the county. When some of these cases began, I had just come back to the county, as I mentioned earlier, in 2013. Some of the local jurisdictions joined in. I got calls from some of the local elected officials, in effect very politely saying, "Are you going to be mad at us if we sue the county?" And what I said was the following, and I just sort of want to let you know this because it goes to how I view this process. First, the answer is no, I'm not going to be mad if you sue the county. I don't encourage it. I think it's always unfortunate when two governmental entities are spending taxpayers' money to sue one another. That being said, these are decisions that were made before I was on the board. I certainly don't take it personally. I might or might not have made different decisions. I wasn't in the chair at the time. As I say, I'm certainly not going to take this as a personal affront. If you think the county has in any way come up short in its duties or its obligations, again, I don't take that personally. The second thing I would say is, even if I had been in the chair at the time, there are times when people in good faith think you haven't done your job the way you're supposed to. The folks who are doing their job say, no, actually, we think we have. If the only way that can get sorted out is by going to court and letting an impartial trier of facts, meaning the court, figure that out, so be it. So you've heard from Ms. Bianca in the County Counsel's office sort of what the status of the two principal cases are here so far. But my own view is, if having gone through this exercise after some period of years, the county's able to say, it's now court certified at the highest of levels, that everything that should have been done was done. My hope is that that'll give some greater reassurance to members of the public that the county did its job, and that'll be, I think, a step in the right direction in terms of moving on with whatever our next set of responsibilities might be. So as I say, slightly different take than you might expect. Let me go, because I want to get to questions from the crowd, because we have a lot. County environmental health. We heard about noise last year. We continue to hear about noise. What are you doing about it, and what are you going to do about it in the year ahead? How's that for a straightforward question?
That's a great question. Again, Michael Ballier, Department of Environmental Health. As a little bit of background, I wanted to let everybody know that about a year and a half, almost 2 years ago, we started receiving a lot of noise complaints related to the plant. And when we started looking further into the issue, it started to become clear that the source, or what we believed to be the source of the primary noise, was coming from a stack that was required to be installed in order to meet Bay Area Air Quality Management District standards. So, it was sort of an unintended consequence of trying to do something to meet another regulatory agency's obligations. But with that said, last year, we embarked upon a study both with the plant, and the plant did their own study in regards to the noise that's emanating from their property. At the same time, Environmental Health did their own, what I'm going to term a blind study. In other words, something completely separate that the plant didn't even know that we were doing. In December, we published both of those reports. The report that was done by the plant was also peer-reviewed by another noise expert. But the conclusion on the DEH side was that we need to continue to monitor this activity. And so that's what we've been doing since the beginning of this year in January. We've gone out on at least 10 different occasions to do noise sampling at various times of the day, and probably even at some of your homes. We've done it at 2 in the morning, 10 p.m., 3 a.m. Our staff is very dedicated into getting out during the time frame that seems to be troublesome. And what we discovered was that most of the time they were in compliance with the county noise ordinance. However, there were 2 instances where we had an exceedance, and we did issue a notice of violation to the plant. Subsequent to that, we exchanged several different letters and ideas about what they can do in order to improve their noise impact on the community. And essentially where we stand right now is they're back in compliance, and they've obligated themselves to pursue a much more formal noise monitoring program moving forward. And they also are going to be, and have done, several different projects to reduce the noise at the plant by installing various gizmos, I'm going to use for as a non-technical term, to help, again, reduce those noise emanating from the different machinery they have up there. Moving forward, we're going to continue receiving complaints from the public. We get a lot of our information from you. We've actually made it easier to file a complaint online on our website, which is www.ehinfo.org, and you can actually fill out the web form with the information that we need in order to be able to analyze that information to determine our monitoring moving forward. And again, as we continue to move forward, we're going to continue to receive information and data to determine how we can best use that for the ongoing noise monitoring.
Before we, I'm going to go with one more question to your colleague in just a minute, so she knows she's here for a reason this year, and we thank you as a newcomer. But I happen to have the noise questions and comments in my hand, and I'm going to read them quickly, and then I'm going to press you a little bit with a sort of a wrap-up question. So, and I want folks to know that their questions and comments are being heard. I've lived near the cement plant for over 30 years, but the noise has escalated in the last year. We can hear it even through closed windows. What can be done to improve this situation? Sometimes it grinds on all night long. Then, have lived near the cement plant for over 30 years. We don't wish for it to close, but would like them to be good neighbors and work with the community on issues of noise and air pollution. The noise emitting from the quarry is loud enough to be heard in our home throughout the night, all hours, wakes us up and keeps us awake. Is there anything being done about reducing noise between 11 p.m. and 6 a.m.? When Lehigh violates noise levels, do they get fined? If not, what steps need to be put in place to impose fines? For example, $10,000 per violation. Does Lehigh host community meetings in an effort to understand the community's concerns? And then there's some other additional questions unrelated to noise. Thank you for your work on the noise issue. How will you continue to reduce/enforce noise mitigation from Lehigh? That's the last of the noise questions at the moment. I'm going to try and bundle those together. If I'm sitting in this audience and I'm concerned about noise, appreciate the opportunity to make a complaint, but that's really not my goal in life. Appreciate the fact that there may be fines on Lehigh, but of course that doesn't make it any quieter. So the question everybody in the room is asking themselves, I'm just projecting here, is what's actually going to be done and when that will make it quieter?
Yeah, that's a great question, and the general summary that I can provide at this time is that the plant has obligated themselves to a much more formal noise monitoring program. And, I think the benefit to that is that I think we all want the noise to go down, right? So whether there's fines or penalties or notices of violation, at the end of the day, we just want to see the noise go down. And they do have several projects that are already in the works to make that actually happen. And in addition to that, they'll be performing and implementing their own more formal program as well, which we hope will provide another avenue for people who are experiencing noise issues to talk to us, but also talk to them. So I think that there's a lot that's being done, and we're hopeful that a lot of that's going to be implemented at the beginning of this year, so in January.
So just to put you on the spot a little, which I get to do because we're from the same organization.
You bet.
If we're back here a year from now having another annual meeting, and there's a question from somebody in the public that says, has it gotten demonstrably quieter in the last year as a result of the mitigation efforts? What do you think the answer to that question is going to be?
I think that the reality is that noise is a very complicated issue, and different people perceive noises in different ways. So what might be annoying or bothersome to one person may not be bothersome to another. And what our obligation is to make sure that the plant is operating in accordance with the noise ordinance. So there are noise levels that are part of that noise ordinance. However, it is possible that people could still be bothered by noise that's being produced even below the noise ordinance. So I do think that there's going to be a lot of progress made over this next year, and our monitoring will also be continue in terms of responding to complaints. And if we don't know about it, then we can't do anything about it. And I really would like to have people submit that information, because we look for patterns of noise, we look for times a day, we look for the type of noise, and the more information we have available to us from you, the better informed and better decisions that we can make in terms of the monitoring.
So there actually is an increased likelihood of a good result if people share their complaints with you.
Absolutely.
Okay, important to know. And then let me just go to your colleague from Environmental Health, who is new to the panel this year and who oversees the county's hazardous materials program in the Department of Environmental Health. I think it would be helpful if we could get just a little more in-depth discussion about what the hazardous materials program's role is in terms of Lehigh, and when do you go to the site, what do you look for when you get there, and what happens if you don't find what you're looking for, as a matter of curiosity.
Yeah, that's a good question. And it came up earlier regarding the overlap in the agency's responsibilities. And the 6 state programs that we regulate, they are generally analogs to things that are also at the federal level. So with the exception of the hazardous waste program, that is something that is delegated down to the state and then delegated down to the local agencies. So we primarily are looking at the cement plant. So it's broken up. It's a large campus, and we kind of look at each individual building that has these chemicals. And again, it's more like industrial chemicals that we're looking at. So we've got 17 different facilities that we have permitted, and there are 50 separate permits that we're looking at in these 6 programs. So what are we looking at? Let's take the underground storage tank program. These are tanks that are underground that are storing hazardous materials. You typically find them at gas stations. They happen to have a fueling facility at their plant. So we're looking to make sure that they are properly monitoring those tanks, maintaining those tanks so that the fuels do not leak out into the environment. One thing that's a little bit different about the hazardous materials programs from some of the other agencies that are here is we really are focused on prevention. we're looking at things and trying to make sure requirements are being met to prevent those releases from occurring in the first place. While if we do encounter spills, we will ask them to clean those up. The vast majority of what we're looking at are things to stop those spills from happening in the first place and to make sure that their personnel are adequately trained on how to respond in the event of a spill, and also that there are emergency response equipment in place, spill absorbent, fire extinguishers, things like that, that will help them if there is some type of an emergency related to hazardous materials. We look to make sure that hazardous waste, these are those chemicals that after you use them, you don't have any more use for them, you need to get rid of them. We want to make sure that those things are properly identified, contained, labeled, and that they go off to the proper facility who can receive and manage those wastes. In the hazardous material storage ordinance, we're looking to see that things are in appropriate containers, that those containers are not just in good shape themselves, but they're also in secondary containment. So if those containers rupture, that something's going to be there to capture that. Like I said, we look to make sure that their emergency response procedures are up to date, employees are trained, that the equipment that they have to respond to spills is available in their designated locations. We're also making sure that things that are above state reporting thresholds are disclosed through the Hazardous Material Business Plan. This is an analog to EPGRA, the Emergency Planning Community Right to Know Act that's at the federal level, to make sure that people are aware of what chemicals are there. We also make sure that if we do see those releases, that they're cleaned up in a timely manner, and that there's a whole bunch of record keeping that comes along with this to confirm that they're in compliance with all these laws and regulations. So that's kind of what we're looking for when we're out there. If we don't find that they're in compliance with these requirements, we issue an official notice of inspection that details all of our observations, including the alleged violations. We will tell them what they need to do to correct those violations, and then we expect a response back within 30 days saying that they have either corrected those violations or giving us a compliance schedule that they're going to meet to get back into compliance. And obviously we have some also additional enforcement tools if we're finding either a very significant single violation or some type of pattern of disregard for the laws and regulations. But that's usually reserved for cases where kind of education and going back out to do repeat inspections and informal enforcement is not working.
All right, thank you very much. That completes all of the questions that I had pulled together with my office in an effort to sort of cover what I was pretty sure were going to be themes in the questions we've gotten. That has in fact been the case, and so if I don't ask your question, it may be because it's already been asked and answered. I do have and we've covered the noise questions and comments, so I don't need to return to those. I had an interesting group of cards that my staff pulled together with the top card says miscellaneous, and so I thought those might be interesting, and they are, and so I'm going to just pull them off and try and make sure they're from different folks and raise some different issues that perhaps we haven't covered. First card asks, what impact will Lehigh Hanson's bankruptcy have on operations or mitigations to water, air, and land reclamation? Lean in.
I guess I'll start. I know we're looking into the matter in our office, and we'll ask Deputy County Counsel Elizabeth Bianca to weigh in. For our office, again, we hold a financial instrument to ensure that the quarry is reclaimed and the conditions of approval are in effect. The bankruptcy to date, based on the research, has no effect on that. That the owner of the owner of the quarry and the reclamation plan requirements and the financial instrument weren't linked to the entity that went bankrupt, and that bankruptcy has not affected.
You said they were or weren't?
Was not, right, and so has not affected the financial agreement or the financial security we have and the requirement that the quarry be reclaimed.
Thank you. Ms. Bianca, anything else you want to add?
I would add, we became aware of the notice probably about 2 weeks ago, and our office is evaluating the notice and also reviewing the financial insurances and our reclamation plan amendment to ensure that there are no issues or gaps there. And that's a process we have not been able to complete in the time period yet.
All right. Is it fair to say you're on it?
Yes.
Okay.
Yes.
I didn't just ask you that because the camera's rolling, Ms. Bianca. Thank you. I want to read this question. It says, can you encourage the maybe to me, can you encourage the planning department to assist the Sierra Club in implementing the Lehigh Sierra Club consent decree? Can you encourage the planning department to assist the Sierra Club in implementing the Lehigh Sierra Club consent decree? Planning department, are you assisting the Sierra Club in implementing the Lehigh Sierra Club consent decree?
I'll put it a different way. So the consent decree requires Lehigh to restore Permanente Creek, and most of the folks up here have spoken to it. We had a meeting with the Sierra Club. They asked about the status. As the county, who's the lead general permitting authority, most office, we're the first ones that Lehigh would come to ask for permits, be it a grading permit or a modification to reclamation plan to restore the creek. And then from there, we coordinate with the other jurisdictions and agencies on the permitting requirements. We had discovered that in the consent decree, there was a timing requirement that didn't, and this is going to sound very bureaucratic, didn't comport to how you apply for a permit from our office. And it's been our observation that that might have caused some delay. But I will say this, when we met as the interagency folks about a month ago to talk about the status of this, it was our recognition that Lehigh had applied to the Army Corps for the initial permits to restore Permanente Creek. And our feedback from the Army Corps is that the permit was in a state that it made sense for all the agencies to start to review it, to process the permit, to get the ball rolling on restoring the creek. Earlier this week, I had a phone conversation with Sam Barquette of Lehigh, and I asked him as a first step, it would be our recommendation to come into our office by the end of this year, December 31st, and apply for the first permit. It's a pre-application where they submit the plans to restore the creek. We take them in, we distribute them to the other agencies here. We coordinate on the permitting process and lay out a path. So again, to date, we're trying to intervene to push the ball forward. Again, we've asked Lehigh to take that first step. It's our hope that after that, Lehigh would then follow up with the permits, we'd coordinate, and that would happen at the beginning of next year.
All right, thank you. I'm going to make two quick observations about that answer. The first is, and I want to read the question again, it says, can you encourage the planning department to assist the Sierra Club in implementing the Lehigh Sierra Club consent decree? Just as a matter of governmental process, it may be helpful for me to underscore the fact that as one of 5 elected members of the Board of Supervisors, I do not have the authority to direct any of the county's 18,000 employees except for the 8 people who work in my office. The only way we take action as a Board of Supervisors is by a vote of 3 members of the Board of Supervisors. Otherwise, it's inappropriate, perhaps even unlawful, for me to turn to a member of the county staff and say, do this, do that. So I don't do that. That doesn't mean I can't encourage, and sometimes I do encourage. So the next thing I'm going to say is, it sounded to me like you are, in fact, cooperating, collaborating, and assisting in the implementation of the consent decree. So consistent with the limitations on my authority, I'm going to say thank you for doing that, and we look forward to seeing that continue in the future, okay? Why has Santa Clara County not issued any financial penalties for violation of SMARA? I don't think you fully understand the role of the county in regards to enforcement. It is the county, i.e. you, Supervisor Simitian, to ensure that SMARA is enforced. This also includes their numerous water violations as well as their land violations. So, financial penalties for violations of SMARA, if any?
I'm back on point. Since adoption of the 2012 reclamation plan, the county has not issued any notice of violations. If we did, and Lehigh was not to comply, we could then pursue levying fines against Lehigh, but to date, there are no notice of violations.
And that is as of, since when again?
Since 2012, the adoption of the current reclamation plan.
And is that because there have been no violations of the current reclamation plan?
There have been no violations of the current reclamation plan.
Okay. And water violations, fines, if any, there?
If you're talking about water quality control board violations, yes, there's a pending settlement that is for $465,000.
Okay, and so that would be in consequence of a violation, and that would be a settlement negotiated, essentially, yes?
It's a negotiated settlement for penalties under the water code.
Okay, thank you. Why not work, next question is, why not work to connect Lehigh, why not work to convert Lehigh land to housing? Isn't it too valuable for its current use? Who is it in this panel that looks up over the quarry and sees condominiums rising up? Planning? Somebody's got to answer the question.
I guess I'll leave that question to Lehigh. And I'll give a bureaucratic answer, which is the reclamation plan requires it be restored to open space. After that time, I've always thought of a stadium. It has a very stadium appeal. But after that time, if the future property owner wanted to come in and propose some sort of housing, that would be a future action.
No comments, please, really. Folks, everybody's been marvelous tonight as they were last year, but I got to ask you to not make comments, not to shout out. These are 10 folks who are here tonight because we invited them. This is not usually part of their job to be out in the community in the evening. Some of them are going to be driving an hour or two to get home tonight. I want to make sure we give them a good forum in which to respond to your questions so that they are back again next year to respond to your questions. So please. The next question is, I have observed bulldozers on the ridge top of the Lehigh Quarry when hiking the PG&E trail at Rancho San Antonio Open Space Preserve. Is this expected?
I would say it's not a surprise. If they're either doing mining or reclamation, then heavy construction equipment would be pretty standard.
Okay. Next question, also for planning, I think. Does the county take the position that Lehigh's permit application for the creek restoration project must not or should not be submitted until the Endangered Species Act consultation process or some other process has been completed?
This would be from the Sierra Club. We gave Lehigh advice early to start discussions with the regulatory agencies first, and that's from experience where we're often, when we're in the position, county planning, of processing permits, that we're not the subject matter experts. We're really the wildlife folks and the water quality folks. They're subject matter experts, is we're often stuck in the middle and we don't add a lot of value. And knowing these folks have a lot of interest and feedback to Lehigh and how it's designed, we advise them to work with them first and get the project to a point where those agencies are happy and then apply to us for permits. Now, my understanding from the Army Corps, I think we're at that point. So to answer your question, no, we haven't advised they get their endangered species permits first, but we did advise that they talked to those agencies to make sure the design was acceptable and then come into our office and apply for permits.
Okay. Folks, some of the questions are what I would call a little bit argumentative, and some of the questions have some notions that are sort of the foundation for the question. I'm going to the greatest degree possible, ask those questions as we did last year, because I think it's better to just ask them and let folks respond. I do want to say to the panel, if you think that the fundamental premise of the question is wrong, feel free to say so. That's part of the answer if that's your point of view. But I think we're better off to just ask the questions, even if they're a little bit aggressive in their tone. To the Regional Water District, your routine testing of Permanente Creek showed elevated levels of selenium in the creek downstream of Lehigh, but it took a lawsuit by the Sierra Club at the urging of local residents to get major improvement in this creek. Why couldn't the district accomplish this? Why did it take a lawsuit?
Well, it's the Regional Water Quality Control Board, where we don't call ourselves a district, but Diane White, the Assistant Executive Officer, answered that last year in saying that we worked with the Sierra Club. The Water Board had been gathering data, saw that there was problems, and when the Sierra Club elected to go ahead with the lawsuit, we provided them the data that was public data and let them take the lead on that. So it wasn't that we had to wait for them to do it. We were gathering the data on our own prior to that.
All right. To the U.S. EPA, your agency has been investigating a major violation at this facility back in the 90s concerning modifications made to the plant without regulatory approval. Where is that investigation, and when will this community see a judgment? Welcome to Santa Clara County.
Thank you. the truth of the matter is, and I understand, I'm new to the actual case itself, so I recognize the long-term process it's taking, and I share the frustration. We at least in the region, have that same frustration in this case. But as I mentioned earlier, I can't talk about the specifics of the enforcement confidential part of the litigation, if any. But I'm fairly confident that a year from now, when we come back, it's likely to be me, that we will have made progress. That's the best thing I can, I think, say today. I have a lot of confidence in the team that's working on this. And as I mentioned previously, I don't know that the modification, this is the new source review program, you probably all know about that. That doesn't necessarily address a lot of the concerns that have been raised here that are very specific and local in nature. And those things, and even if it's a fine, et cetera, will not put the business, put them out of business. So they will continue to operate, I would assume, to the extent that they're able to. And so EPA's case, to the extent that it's resolved in the near future, may or may not have a dramatic impact on the things that are being raised here. But I share your frustration. There are several cases like this that I've inherited that my preference would be to move them forward, but it's at a higher level of decision making than me. So.
All right. Well, thank you for that. Good to hear your optimism that progress will be made during the course of the coming year. And I'm going to turn to my staff and ask them to make that a question that I ask next year to say, how did that turn out after the year passes? So we'll see you then on that issue. We're going to schedule around your schedule, and thank you. We have a number of air quality questions. So, particular matter continues to be an ongoing issue. In April 2016, the Bay Area Air Quality Management District stated that a new general rule for particulate matter was to be developed this year. What is the status? How are the ridgetop stockpile and storage areas being managed to reduce fugitive dust?
Okay. I did talk a little bit about our rule that's specific to this particular facility. That contains the requirement for a dust mitigation plan. So that has been developed by Lehigh and is in our hands. In conjunction with that, in our attempt to get continuous improvement, we do have a general fugitive emission dust rule that's going forward. That is being developed right now. It's for everything from Lehigh to construction dust to dust off of open areas. That rule is going to be workshopped sometime in January and adopted sometime mid-year next year. So that is another rule that is applicable to Lehigh. It's just not one rule. We develop a whole suite of rules that are applicable to various industries.
All right. I've got three questions from the same questioner, and I'm going to try and lump them all together. Question about dispersion models that rely primarily on the air currents at the stack instead of distant airports, So when will the dispersion models rely primarily on the air currents at the stack instead of at distant airports? Then a question about benzene in the ore and whether or not Lehigh should be required to measure and report benzene, and a question about how many pounds of mercury are discharged from the Lehigh facility each year. So mercury, benzene, and measurement and modeling.
Okay. So I had discussed earlier about our risk reduction rule, and that has to do with hazardous air pollutants. HAPs is what we call them, hazardous air pollutants. That includes all the compounds that you just discussed. So what the new rule will do, and Lehigh is subject to an older standard, is require them to inventory what they have, look at their emissions, their true emissions coming out the stack, their true emissions. We do some calculation on the fugitive emissions, which are the emissions that don't come out of the stack, that are developed, that come out of trucks, come out of other operations on the facility. Those are combined. We run it through these models that are by the Office of Health Hazard Assessment, and come up with a risk to the community, an additional risk to the community. So that's what's happening. We are in that process, and I had mentioned that we're hoping to have the rule adopted by our board sometime, I think I said first quarter, end of first quarter, second quarter of next year. So we are currently workshopping those. That is specifically designed to address these issues. The modeling, the dispersion modeling, rely on, and I talked about that earlier also, topography, wind currents, the height of the stack, the exit velocity of the materials coming out the stack. And because the stack's so high, what we believe is that the health risk assessment model is not going to show that as being too much of a risk, what's coming out of the stack. What's going to drive the risk for this particular facility is the fugitive emissions, the dust emissions, the truck emissions, because those are at ground level, and those are what are going to really impact the local communities. So the higher dispersion, that has there's more of a dilution factor. We do measure those compounds. We know the concentrations coming out there. So that has a tendency not to drive risk factors. The low ground level ones are really what drives risk, and that's what we're going to be concentrating on.
Besides the 30-day rolling average max, why is there no daily max on emissions is the question.
Okay. Because we're talking about the material that's coming into the facility. So I had also talked about earlier about the variation in the material, that there's different levels of nitrogen compounds in that raw material coming into the facility. So it depends on where they're mining, that the chemical composition is different. So to get a handle on what is coming out the stack and so forth, we do this 30-day average, so it averages the material coming into the process so that we have an idea of what's actually coming in, and then we can control what's coming out. So it's sort of an in-out thing, and so that we can have a handle on what's acceptable coming out the tailpipe, basically.
Next question is HCl acid being monitored at the single stack? HCl acid vapor etches car windows, etc. Has HCl acid vapor been reduced?
Yeah, that's HCl hydrochloric acid. That is being monitored at the stack, coming out the stack. And again, I had talked about that this stack, there are limits on HCl, so they have to meet certain standards. But again, that material is coming out the tall stack, so the exit velocity of that goes quite high. It's lofted up into the atmosphere, and so it doesn't really have, I won't say it doesn't have any effect, but it has minimal effect at ground level. So that's what that whole stack, that whole system is designed to do. It's sort of a multi-pronged approach. You limit what's coming out the stack, and what's exiting the stack gets diluted enough that there's no impact on the community.
All right. Next question is from someone who first makes the statement that Lehigh is the major contributor to air pollution in Santa Clara County. Is there information available on the Lehigh impact to air qualities on a city-by-city basis? And if so, how do we access that data?
I guess I'm not.
I'm going to rephrase it
please.
slightly.
Yeah.
I think what the question is asking is, to the extent that Lehigh contributes to air pollution in our area, is it possible to measure that air pollution contribution?
Oh, I see. Okay.
Differentially from Cupertino to Los Altos Hills to Los Altos, for example.
Yeah, very difficult. We know what's coming out the stack. We know about that, and that modeling effort helps in that. But if we are to target certain areas, we can, predict, doing wind analysis and so forth, what their impact would be on a certain area downwind to some extent, but not to any sort of accuracy, I believe. We have regional monitors that monitor the region's air, and the impact of those facilities are supposed to, the controls on those facilities are supposed to limit the impact on the region. So I would say that impact would be minimal, but specific to a city or to a certain downwind area, that would be dependent. If what's coming out of the stack is compliant with all the regulations that we have on this facility, I would say there would be minimal impact. If they had a excursion of some sort, that's when we would do the modeling and look at the specific excess emission and where that impacted on ground level. So we would do that analysis separate on an episodic basis. So generally no, but on an episodic basis we could do that.
All right. We've got 2 or 3 different questions from different folks, all asking about the potential for the use of a cleaner burning fuel, specifically natural gas, at the site. Thoughts?
Yeah, right now, our rule doesn't specify what they could use as fuel. They currently use coke, but our rules do specify, again, the emissions that result as a result of burning that coke. So there are controls specifically designed for this facility to limit the emissions coming from this burning, and Lehigh is in compliance with those. So we don't specify the kinds of fuel that they use, but we do limit the emissions. There are other trade-offs with natural gas that we have. There's greenhouse gases, there's other things, there's lots of things that are balancing trade-offs that go with burning different kinds of fuel. So we concentrate on what they use, what the facility uses, and to minimize or to limit the emissions from that.
All right. I want to acknowledge that one of those 3 cards on that question was directed to me as well as to you, just so that the questioner knows that I see that it's addressed to me as well. And I want to try and summarize your answer by saying, you say what they have to, how they have to perform. You don't tell them how they perform to get to that level. Is that?
That's correct.
Okay. Question is, what fraction of particulates from Lehigh stacks lands on nearby neighbors' cars? Is it more these days now? What's the thinking about? We do get questions fairly frequently in my office about particulates and people saying that they are pretty sure that the dust or haze that has settled on their cars and other parts of their homes is from Lehigh. Thoughts?
Sure.
I would say that we get hundreds of complaints about facilities. We get quite a few complaints about Lehigh, dust, visible emissions from their stack and from other areas of Lehigh. So my answer to that would be probably from the stack. Again, that's not probably impacting locally the real neighborhood. What you're seeing is probably dust from the facility for certain. It could be track out from the facility itself. It could be trucks, cars coming out of the facility, tracking out and it landing on your properties. It could be a number of things, and that's what this general dust rule that we are talking about, that we're developing to limit track out, to limit other things, would do for this particular area and this particular company.
I'm going to go to a noise question in just a moment, but first I'm going to ask the audience a question, and then I'm going to come back to you with one more question, if I may. And I want to say, one of the challenges when we have this conversation is that the range of technical expertise, as you can tell from the questions and from the answers as well, is all over the map. So there are some folks here, I'm sure, who just say, look, I've got a general concern. There are others who, as you can tell, have very specific knowledge and have very specific questions. How many of you think of yourselves as relatively well informed about the technical aspects of this conversation? And how many of you would say you're just more sort of generally interested or concerned? Okay, about a little different than half and half. So with that in mind, I'm going to ask you a really unfair question, but we'll give it a try.
Okay.
So all of that technical expertise set aside for just a moment,
okay.
Given what you know, do people have reason to be concerned about human health as a result of the emissions from the plant?
Okay. I would say if I were living in the neighborhood and that plant was operating near me, I would be concerned about dust fallout. I mean, I think that's a natural thing. If you're a susceptible individual, you have asthma, that would be more affecting you greater than if somebody who didn't. So I would be concerned about that. The Air District, we do listen to you. We understand that, and so that's why we are going for these additional rulemaking to try and limit that exposure. That's what this health risk rule is about. That's what this dust control rule is about, to try and limit or reduce your exposure. Not, the visible emissions, what you see coming out the stack, that's probably not affecting you. But the ground level stuff that I've been talking about, the stuff that you can't see but you see fall out on your car overnight because of the dew, those are the kinds of things that we're trying to attack now, because I think that's what's going to drive, and I had told it drive the health standard, the health risk that we were talking about.
And is that in connection with the sensitive populations that you specifically articulated interest in your very first opening statement?
Yes, that's to try and do that. And I had talked about the Office of Environmental Health Hazard Assessment. They're particularly concerned about those sensitive individuals. That's why they lowered their standards on exposure for that, and that's what we're adopting.
All right. Going back to noise, the question is, why isn't it a consequence of excessive noise and noise violations that operations cease during the hours when residents have a legal right to quiet enjoyment, that is 10 p.m. to 6 a.m.?
That's a very fair question, and the noise ordinance for the unincorporated areas does have a limit from 10 p.m. to 7 a.m. that is quite a bit lower, so that people can have that enjoyment. Now, environmental health is not in a position to dictate from an operational standpoint of when people can't or can't operate their business or their party or whatever they're doing. And ultimately, they have to be in compliance with the noise ordinance. So as long as they're under that limit, we don't have the ability to require somebody to not perform their business function.
So to paraphrase my earlier comment, you're saying you regulate performance, but not the operations that might lead to either compliance or a violation.
That is correct.
And how often have you identified violations? We've talked about this a little bit earlier, but on the noise side.
On the Lehigh cement plant, we had 2 readings in April that demonstrated a violation.
And are those your only 2 readings during the last year? Or, excuse me, 2 violation readings in the last year?
Yes, in the last year and a half, we've done over 24 different readings. During those readings, only 2 of those actually resulted in a notice of violation.
And have those readings, you all think I know the answers to these questions. I don't, so I'm curious along with you. And have those readings taken place during the evening?
Yes, primarily during early morning and late evening hours, anywhere from, we actually do try to target the 10 p.m. to 7 a.m. because that's when the most stringent standards apply.
And that 10 to 7 period that you just mentioned, were the 2 violations during that period, or were they some other part?
Yes, they were. They were in that period of time.
And were there penalties?
There were not penalties. We issued a 30-day notice to correct, and they did so.
And is that standard?
Yes, that is standard. In almost every situation, we give an owner the opportunity to correct it before we start issuing penalties.
And I don't have this question, but assuming I did, somebody might then say, well, how bad does it get and how frequent does it have to be before there is a real penalty, quote unquote?
Every situation is different, and the extent of the violation and the extent of what they do in response to that is all taken into account. We would also typically sit down with county council and talk with them. So that's a very difficult question to answer in general, but every situation is a little bit different.
And I thank you for continuing to respond, and I'm going to keep asking a couple more questions.
You bet.
And the next one is, who makes that judgment about whether or not to impose a fine?
So the judgment is actually something that we look at in almost every instance, but it's our normal policy, as I said earlier, that we give a 30-day notice to correct. Moving forward with penalty actions is something that we don't take lightly. It is something that we look at very seriously. And again, we would probably have conversations with our county council to help make that decision as a team.
As a team within environmental health?
Environmental health and county council, yeah.
Okay, so ultimately, environmental health, under the advisement of county council, makes that judgment. Is that
Yes.
a fair summary?
Yes.
And if there are penalties, how is the size of the penalty determined?
So, currently when you look at the noise ordinance, it does not have specific guidelines or information regarding penalties. It has some slightly different enforcement provisions, which talk about the county being able to provide or file for injunctions and that type of thing. The goal of the noise ordinance is really to get the noise to be reduced, not to institute financial penalties, which would then allow people to continue to violate the noise ordinance.
I know last year and since last year, I've gotten a number of questions about whether or not the county's noise ordinance is less stringent or more stringent than local ordinances in surrounding cities. Can you address that question?
Yeah, every jurisdiction has its own noise ordinance. So, for example, the City of Cupertino has an ordinance that applies within the City of Cupertino. And you might be saying, well, Mike, I live in Cupertino, but you guys have come to our house and done measurements. And the reason why is because the unincorporated area is our primary jurisdiction, and if the suspected source is in the unincorporated area but actually affects you in the city limits, then we would apply the noise ordinance for the unincorporated area. And we've looked at the City of Cupertino's noise ordinance, and in fact we are more stringent than the City of Cupertino's noise ordinance in terms of the decibel limits.
Is that the case in the evening as well as during the daytime hours?
Yes, that is the case.
Okay. Thank you for that very responsive series of answers.
You bet.
I want to move on to water quality, mindful of the hour. Someone says, I live on Permanente Creek and notice that the water flow varies greatly from week to week, flow and no flow. How much control is the plant allowed to have on creek water? Where does all the water that the cement plant use go?
The cement plant tries to recycle as much of the water as they can, reuse it within their facility, but groundwater comes into the quarry on a regular basis, and then they pump it out. They are now treating up to, at least 400 gallons a day, 400 gallons per minute with their interim treatment system, but that doesn't treat all the water by any means coming out of the quarry. The full treatment system will treat all of that water coming out of the quarry. But their pumps, they operate them based on their operational needs. So when they turn on the pumps, the creeks will go up, and if it's in the middle of a dry summer, the creek could go dry. I don't know if we have control over when they turn on those pumps, but I don't believe so.
All right. Water pollution continues to be an ongoing issue. The EMSA, the East Materials Storage Area, is a newly created source area of pollution. What is being done to control pollution from the East Materials Storage Area?
The county is working with them through the reclamation plan to deal with the East Materials Storage Area. The Water Board is also going to be dealing with that from the standpoint of the final solution there needs to meet what's called Title 27, which is regulations for dealing with solid waste, and waste from mines is included in that. They have, Lehigh and the county came to an agreement to put cover over the East Materials Storage Area, and we agreed that's a no-lose situation. That's a good thing to do. It does isolate the waste to some extent. We don't think that that's the final solution by any means. Our staff is now reviewing groundwater data and the impacts of groundwater, interaction of groundwater with surface water at the site, and as well as looking at the stormwater controls beyond the cap to see to look at the effectiveness of that at reducing selenium from being discharged from that waste. We won't have a final recommendation to our board on that for about a year. We have another year's worth of groundwater data and surface water data to collect for that. And at that time, our staff will start working on a waste discharge requirements, which will specify the final construction of the cap, and whether what they've done so far is not the final cap by any means.
Yeah, I don't have much to add. I'll just add that both our agencies work together on the East Materials Storage Area. I will admit the results we've seen to date have not met the standard. Lehigh has put a cap on, and the intent is to prevent contact, again, between the rainwater and any selenium, any limestone-bearing material that's in the East Materials Storage Area. The first year results was over. We've had our experts, we hired a hydrogeologist to come and look at it. We consulted with the regional board. I think the prevailing thought was in the first year it needed a bit more settling out and work, which I know Lehigh did during the summer period. They put in some interim stormwater measures to contain the water that comes off of the cap. Again, it's our hope that this stormwater season, well, it's my hope in general we get a lot of rain, but when it does come off of that site by working on the cap, making sure it prevents that contact, putting in the new measures, it's going to bring the selenium water levels down.
Okay. Next question. Santa Clara Water District, why do you say that the Stevens Creek Reservoir is within your pollution limits? Note, this water is, I think it's out water and goes down into the recharge pond and then into the aquifer and eventually is pulled up by the California Water Company and the San Jose Water Company. Lehigh also pollutes the Stevens Creek Quarry and the Stevens Creek Reservoir, according to the questioner. Water District?
I like the East Material Storage pile better. Stevens Creek is connected to Permanente Creek down below Fremont Boulevard, so between Fremont and El Camino. Stevens Creek Reservoir, I'm not sure about the pollution issue. We know that there's mercury in Stevens Creek Reservoir. We have an ongoing oxygenation system there to deal with the methylmercury. We also monitor it for mercury. So I'm a little confused about, I don't have a history of saying no pollution. It is not connected as a recharge source other than it recharges. Stevens Creek Reservoir would discharge to Stevens Creek, and Stevens Creek would recharge through the gravel in the bed. So again, it's kind of similar where in the upper watershed, you're going to have recharge that may end up at, eventually over years, at a water well in Mountain View or Los Altos. But then any water that's recharged further down in Stevens Creek ends up in the shallow aquifer, which essentially is not used for any drinking water purposes.
All right, thank you. I am mindful of the time and want to wrap up here shortly. I'm going to get to the issue of unanswered questions in just a minute. I do have a question just about process. Someone writes, last year asked about public reports from the biannual coordination meetings. Are these reports being issued? And I think the answer to the question is there are not minutes kept of those meetings between and among these various different agency representatives and participants. This meeting is the opportunity to sort of report out about what has happened in their conversations, as well as more broadly, obviously, over the course of the previous year. So this is the report out mechanism rather than a formal report from those two meetings that take place every year. Again, mindful of the time, what I'm going to do is say thank you to all of you for being here. We got to most, but certainly not all of the questions. And we did cover, I think, pretty much the range of issues here that people raised. I should be candid with you and tell you that if you had a really, really long question, and some of them ran 4 or 5 card lengths long, then I probably went towards a question that was going to be a little bit quicker and to the point. However, last year, we took a suggestion that I thought was very helpful, which was to the extent that we have unanswered questions, we try to get answers to them after the meeting and post them. I believe we did it on the planning department's website. We're going to do that again this year. So if you have a question that was asked, and it's in the pile here, and I have a pile of unasked questions, we're going to try and get you an answer and get it posted on the county's website. Please give us a little time to do that because we have different agencies that we're going to be reaching out to, and we're going to be dependent on their ability to get back to us, but we want to try and make sure that in addition to the questions that were asked and answered tonight, other questions get addressed as well. I want to ask one quick question. I think I know the answer, but I just want to be sure. Again, thank you all for coming. Every year, folks, when we ask them, say, will anybody come? And I say, oh yeah, they'll come. The question is always, where do we hold the meeting? We could have held this meeting at 70 West Heading Street, which is the county government center. In general, it's my preference to hold the meeting out in the affected community. How many of you would have found it more convenient, feel free to raise your hand, had we done this at 70 West Heading Street in San Jose? No. Okay. How many of you find it more convenient to hold the meeting right here? okay? Okay, all right, thank you. You just want to double check what your assumptions are. Thank you for that. I also want to thank the panelists again. As I mentioned earlier, this is not part of their daily routine. This is a little out of the ordinary in terms of trying to pull folks out into the public, give you all, us all, direct access to them, and ask our questions in a respectful but direct way. I think their presence was crucial to the success of the evening. As I say, I know a number of them have a long way to go home tonight, so thank you again for being here. Could you join me in giving them a round of applause as thanks? Again, I want to thank the City of Cupertino for hosting us tonight. They always make it easy, and we appreciate that. One last comment or question, or maybe I'll blend the two of them together. It is my hope that you find these meetings genuinely useful, both to learn what's going on and to get answers to your questions. If you have an opinion about that, please feel free to email me at my office. My email address is on the back of the agenda. If you think there are things we can do better, feel free to say so. If you think there are things you'd like to see changed, feel free to say so. Can't guarantee that we're going to move in that direction, but I don't know if you don't tell us. So please tell me in my office what you think of the format, the approach, whether it's useful, whether it's not useful. Is annual about the right way to do this? These folks are probably not enthusiastic about monthly meetings, but you never know. And lastly, I want to thank my own staff, Christina Loquist, Christine Pryor, and Gabe Carhart. Thank you for making tonight's possible and for making the meeting run so smoothly. Have a good evening. Drive home safely. Thank you.